So today, welcome to the Snap Wednesday webinar, and we're delighted to have Lydia Dunford from Boys Turner back again. We love Lydia's webinars because they inform us so much and give us so much information, and I'm sure today will be no different. So today Lydia is going to talk about the SEND National Tribunal trial. And I will pass right over to Lydia, and we're going to go through the session, and I will be asking Lydia some questions and then she will be answering them. So the first question, what is the SEND Tribunal National Trial?
So SEND is Special Educational Needs and Disability Tribunal. The national trial is something that has been in place since April 2018, and basically the tribunal wanted to run this trial to extend their powers in making non-binding recommendations about health and or social care parts of an EHCP appeal. So specifically, this allowed parents and young people from the 3rd of April 2018 up till now to make appeals and have this considered under the trial if they were appealing about their local authority not issuing a plan in the first place, what the educational parts of an EHCP say, and they're challenging that. The LA not carrying out a reassessment of needs, not amending the plan following a reassessment or an annual review, or a local authority deciding to stop a plan entirely. So in any of those circumstances, parents or young person can ask the tribunal to also make these non-binding recommendations about health or social care, provided there's an educational part to their appeal as well. That was the kind of the key requirement of these.
So the next question, what does it mean now the trial has ended?
So the trial was reviewed a couple of times since it began, and it was due to end initially end of last August 2020, and then it got extended for another year. And then the most recent update that was issued, I think the 20th or 21st of July from the government, was actually the trial is going to end, but the tribunal will continue to have these powers that they've been able to use throughout the trial process. So the tribunal basically can keep making these non-binding recommendations about health and or social care in an EHCP appeal, but provided still that there is an educational part to the appeal as well.
What happens if the educational parts of an appeal get resolved, but I still want the tribunal to look at health or social care?
So this is something that can happen and does happen depending on the circumstances. From our experience, is the tribunal will still allow the appeal to continue and address anything that's outstanding. So if that is health or social care or both, provided that the appeal was initially lodged about an educational part, so the educational needs, the provision or the placement in the plan, for example, the tribunal will still continue to deal with the outstanding points, including going to a hearing if that's needed.
So if an appeal gets to a hearing and includes health and or social care, how long will the hearing be and how many witnesses can I bring?
So if you get to a hearing and it's under the former national trial, but it's regarding health and or social care, you need to prepare that the hearing is going to last for 2 consecutive days. That's the standard time frame the tribunal will set. This is something that they will set out from the off. So when you lodge the appeal, so if matters get resolved during the course of the appeal, but you've still got health and social care, still be prepared for it being 2 days, unless the tribunal says otherwise. Often the second day is used just for the panel to deliberate. So usually parties, their witnesses aren't required to attend, but we would always say make sure everyone's available across those 2 days, just in case that someone's required to give further evidence or evidence on that second day. The tribunal will be reviewing appeals anyway throughout the lifespan, and then in the run up to the hearing date, they will let parties know about if the hearing is going to be 1 or 2 days, and that will depend on what issues are outstanding. In terms of witnesses, the tribunal has set out this, again, this was under national trial rules, so we presume it will continue when the trial has ended, is that if you've got an educational appeal about an EHCP and you're also challenging health or social care, or both, then you can have up to 4 witnesses as standard. If you're not challenging health and social care, then the standard number is 3. Really, that extra witness is there to allow someone from health or social care to attend, and who your witnesses are, that will depend on the issues. It may be that you need someone from health and social care to attend. Maybe you need just one of them or neither of them. But again, it's worth making sure that any witnesses are kept up to date about any changes in hearing days, lengths of hearing, and make sure that they are still available.
And are those hearings always in person, or are they doing any of them online because of COVID?
So they've been online since the first sort of lockdown really kind of came into force. They've been remote, and actually they've worked really well for the most part. And a lot of people have preferred them because you don't have to travel. That saves a lot of costs for parents. It saves witnesses fees for traveling. It also has meant a reduction in hearings being postponed because of lack of venues, lack of suitable venues. I've had a number of hearings in the past year, and none of them have had to be postponed or changed because of any issues, which is great. It means you get a decision quicker. I think the plan for hearings is probably going to be remote going forward, but that doesn't mean there won't be some hearings where they are better to be held in person. I think it's probably going to be a case of, in the circumstances of that particular appeal, is it going to be more appropriate to have something in person rather than remote? But yeah, for now, for the foreseeable future, it seems it's going to be remote.
It's nice to hear some actual benefits from the COVID situation.
Yeah, absolutely.
So what happens once SENDIST has made their recommendation about health and social care? And first of all, what is SENDIST?
Oh, so SENDIST, that's sort of jargon for the Special Educational Needs and Disability Tribunal.
Okay.
Yeah, the SENDIST was kind of their sort of name that you still see round and about, or the SEND Tribunal. So if you've got to the stage where you've got to a hearing, you still have health or social care, or both, that they need to discuss. So the hearing will go ahead, they'll hear evidence from witnesses, and once it's concluded, the tribunal will issue their decision. And in that decision, which will go to both parents or the young person and the local authority, they'll set out any legally binding decisions about education, if there's any educational parts still in dispute, so about needs, provision, placement, and the local authority has to follow those. That's a legal requirement. If there's also health and social care, the tribunal will set out in that decision their recommendations. So it will basically be phrased very similar to how they would any other part of a decision. They'll say that if they've considered the evidence, this is what they think is required. But it will be clear it's a recommendation. They cannot force the local authority or the relevant health body, CCG, to provide this. Essentially, what will happen is, if we look at health and social care separately, it makes it a bit easier. So if there's health recommendations in this decision, the relevant CCG will be sent a copy of the decision as well. They have to then respond to parent or the young person and the local authority within 5 weeks, saying what steps they're going to take in response to these recommendations and give reasons if they're not going to follow any. The local authority then needs to send a response of this once received to the Secretary of State within 1 week. and then that is health. Social care is very similar. The local authority, they will get the decision because it's social care comes under the local authority kind of umbrella. They have to respond within the 5 weeks and again confirm the response. If they're not going to implement all recommendations, why is that? And again, a copy of that needs to go to the Secretary of State within a week. So it does take a little bit of time. It's not an immediate change overnight that there's suddenly this extra support or change of provisions going to be in place. But similar to the educational parts of an appeal, there's also a timescale for these to be implemented by the local authority. It's up to about 5 weeks plus a day from the decision. So none of it happens straight away. And from experience, in terms of social care, there was a bit of delay on a case I had that was heard end of last year. We had the decision early this year, and there was a bit of toing and froing to get ultimately full agreement from local authority social care that they would implement all recommendations. They started off saying, no, we don't agree, and there was a bit of back and forth to try and get to them why. They eventually said, okay, no, we will. There are a few extra bits that they put in there as well. And it's important, I suppose, to remember that even if they do follow some recommendations, if not all, it's assessing it overall. Is it actually overall, is this going to be much better than what it was? Bearing in mind they can't be made to implement these recommendations, which can be frustrating for parents, especially if you've gone through a whole appeal and you've got a really clear decision in your favour and it's followed your, independent evidence. It can be very frustrating, but I suppose something which may come up as a question, or I'm happy to just go through anyway, is there are options that parents can follow if they're not happy with the social care or CCG response, if they're not planning to implement the recommendations. So yeah, I can go through those if there's any questions, or if not now, whatever's easiest.
And how, in your experience, how often do the recommendations not get sort of put through?
Well, I think overall, it seems to be that generally, well, I think the way it's probably looked at is the expectation is local authorities and CCGs should implement, because the decision has been made by a specialist tribunal that has considered all the evidence, and this is what they've concluded. I think generally provision is put in place as recommended, but I don't think that can be said across all appeals, because obviously depending on what's been recommended, some of it may be a really high amount of additional care or social care hours or respite, and it may be quite a lot compared to what was there in the first place. So ultimately there's going to be money is going to come into it in some form, even if it's not said as much. Yeah, I think from our team and experience, I think generally recommendations are fully implemented, or as close to, or at a level where parents are happy with that and they go, yes, actually this is acceptable. But yeah, it's one of those things where it sometimes feels a bit bittersweet for parents, because you go through this and you just want it just to kind of round off nicely. And I suppose it's balancing that with local authorities do have to manage their resources. There's not unlimited money. But like I said, there are options that can be followed if these aren't implemented and you think actually there is scope to challenge this. If the reasons for not implementing the recommendations are, if they're poor, if they don't really cover it.
So I think that was all the questions that we actually had. So are there any questions in the chat, Janet?
No, there isn't, but maybe it's a good opportunity to maybe look at the options and discuss what kind of options if a family wanted to challenge that idea.
Yeah, no, that's absolutely fine. What I can also do afterwards is send you a link to an article that I wrote about this actually, I think kind of last year now, setting out the options, and that's essentially what I'll be referring to.
Okay.
It's quite a useful little how-to guide on what parents can do. And I will stress with these as well, none of them are quick fixes, and they do take obviously time and effort, and potentially money as well if you're looking to do that through legal advice as well, which I think we'd also say, I'd say that as well, if parents have got an appeal with health and social care, to look to get advice earlier on, because they can be quite complicated, and there's a lot more, potentially a lot more evidence that has to be factored in than wouldn't otherwise. So that would be the first point I would say, is look to get advice early on. If it's something where you've got your decision and you're the CCG or local authority social care aren't following the recommendations, like I say, it's expected that they will follow them. But the tribunal, first of all, can't do anything further to make them. Once they've made their decision, they are very clear, that is the end of our role in this. That's it, it's over to you, parents. So there are options through complaints, through the complaints process to the local authority or CCG. These can be escalated to either the local government ombudsman, social care ombudsman, or there's a parliamentary health service ombudsman. So again, they all do take time, and I suppose, it's balancing the potential end result and the potential change and increase in provision at the end of it to actually the time and effort to go through it. And it feels quite unfair for parents that they have to go through this after having gone through a lengthy, appeal process. If you go through those processes and you get to the ombudsman and it's not satisfactory, there is a last resort of judicial review, which can be very costly. It can be time consuming, and there are set kind of criteria of when that can be applicable and timescales for it. So we would always say, get advice earlier, even if you're thinking about it or you just want to check to see if the recommendations are being implemented or the response to these are sufficient. Otherwise, ultimately, you will always have a next annual review of the EHCP. If it's something where parents feel it's not perfect, it's not quite the recommendations, but it's good enough for now, you can always wait for the next annual review. Worst case, you could go through another appeal if you really wanted to. It's just kind of finding that balance of what parents want to focus on and what the situation is going to be like for their child or young person. But yeah, we would always say, even having just an initial conversation with us in the team, just to get an idea of what your options are and potential next steps, I'd always say do that.
Yeah, it's a lot of energy as well, isn't it? These families go through a lot to get there to that point. Exactly,
it's a lot, and yeah, like I say, it's by that point a lot of parents just want it just to think, no, we just want to have what is here now and just make the most of it. But I suppose it's also worth bearing in mind that local authorities will always be reviewing what's going on as well and their provision, and so that will come up in annual reviews. The case where the local authority did eventually agree to include all the recommendations, they also added in that they wanted to do a kind of interim review of the social care as well, kind of halfway through the year. So sometimes there's a bit of compromise as well, but I suppose it's remembering that unfortunately these things they're not set in stone, but I think if you go through an appeal and you get a good solid recommendation and decision, that ultimately will stand you in much better stead going forward if you do need to make any further changes potentially.
And would parents who have a child with a disability, would they be entitled to legal aid, or is it a real individual kind of case?
So legal aid, so we don't cover legal aid. We don't have a legal aid contract at our firm. My understanding of legal aid, and I would always say for parents, if they think they're eligible or their young person who is not a child, it'd be in the young person's name, I'd always say check through the civil legal aid advice line if you're not sure. My understanding is it can be available for send appeals. I don't know if that necessarily covers tribunal hearing representation. And experts, I think there's fairly strict requirements on experts' costs, but again, I would say to check that directly because I'm not an expert on it.
Sure.
In terms of options past an appeal, then yes, there is legal aid, I believe, for matters like judicial review, which can be in the child's name. But I would always say to check that before parents or young person are thinking of doing any of these if they think they might be eligible. because I do know that I think there are strict criteria at any stage.
Sure, thank you. Super. So thank you very much, Lydia. That was very informative, and I've learnt a lot
Thank you, Lydia.
about that. We will be, as I say, this has been recorded and it will be posted up onto our website. And I think in the chat there should be a link to the recorded websites, and it will hopefully be on there by the end of the week. We've just got a new website which we're still sort of doing a bit of work on, so there isn't a link right at the front, but I believe that the link is in the chat there. And we have your email addresses, so we can email you a copy if you would like to have that email to you. So we will conclude the sort of recording now. If nobody else has any sort of questions they want to put in the chat. Or something's just popped in there. I don't know.
Jackie, it's just Jackie popping up the links.
Not just Jackie, that's Jackie. Thank you. So thank you very much again, Lydia. And I think, you know, what we'll do now is if anybody would like to, you know, basically unmute and turn their video on and just ask Lydia a question, then now is the time to do it. Please feel free. I can see the numbers on the chat going up. I can't actually see what's in the chat, but if there is anybody who would like to ask Lydia, please feel free to unmute and turn your video on if you would like and ask a question.
I've just added the link
oh, lovely, thank you.
To the Ask Connor website. We do have more information on our website as well about the trial, particularly following as the trial was kind of going on last year. So I'd say have a look at that as well. There is government, kind of official government kind of consultation response to it. I admit I haven't read it because it's incredibly long, and it's many pages, but there is information if people want to have a look into kind of the nitty-gritty of it. Have a look on the government's website. In fact, I can add that on now. It's
oh, great, thank you.
Yeah, they've got some kind of guidance, and yeah, it's it'll be good hopefully if it stays for, you know, for the foreseeable future. That would be great. I mean, an ideal world would be the tribunal can make legally binding recommendations for the entire appeal, you know, process, but that may or may not happen. We'll have to wait and see.
Super, thank you.
Sorry, Janet, did you see the question?
I'm not actually.
Okay. When must the local authority notify the parent that they have decided not to issue an eco plan, please? Eco plan, please.
Eco? I don't know what. Do you mean EHCP?
Yes, I think it's in a typo. I'm sorry.
So when must they let you know if they've decided not to issue a plan? So that if that's following, which it normally is following an annual review, they need to issue confirm what its decision is within 4 weeks of that. If they are planning, so it should be 4 weeks basically. If they are late, then you should write to the local authority and say that they are delaying your right to appeal their decision. But yeah, it should be 4 weeks from an annual review, if that's what they're going with.
Yeah. Does that answer the question? Oh, yes, thank you.
Super. So does anybody else have any other questions they'd either like to put in the chat or to ask Lydia directly? No. You've covered it all, Lydia.
Yeah, if anyone has any thoughts or questions afterwards, then my email's in the chat, so feel free to email me. That's absolutely fine.
Super. That's great, lovely. Well, thank you again, Lydia, and thank you, Janet and Jackie behind the scenes, and thank you everybody for joining. I hope that was.
Sorry,
there is a question. It's just
there is. I'm sorry. Yeah.
Can you see that, Lydia?
I can.
Yeah.
They finalised the EHCP based on a type of school, and we lodged an appeal. Okay, they have now named a school, and we want to change the plan. Can they do that? Yeah. Well, if you've already lodged an appeal, the LA still could. It could still issue an amended final plan. That would give you a new right of appeal. what you would probably, if you don't agree with the school named, which I'm guessing you don't, then you would need to look to incorporate that into your appeal. So depending on how far down the road with your appeal, you could update the grounds of your appeal and say, we now have this final plan, which is issued since the previous. It names the school, we want to challenge the school specifically rather than just the type. That should be fine to do, and then you can work off the basis of that new plan if you need to. If it's the same as the old, just they've named a school, then you can just use that one.
And there is one more there.
Another one. All right, so there's a follow-up to just okay, right, so in response to what I was just answering about the 2 EHCPs, so you wouldn't need to lodge a new appeal. If you've already lodged one, then you can just incorporate into that appeal the fact that there is now a school name specifically and you want to challenge that. So not the way that you would do that would be through a request for change form, to say you were initially appealing just the type of placement, you now want to challenge the placement named. If you do want to challenge it, that shouldn't be much of a problem, I don't think. And then you would just incorporate that into the appeal. If you've got any other questions, I would say drop me an email, because it might be easy to have a chat about it. The other question is the burden of proof in an appeal regarding the LA refusal to issue an EHCP on the parents, the LA, or both? So, I mean, really, it's challenging. First, it's challenging the LA's decision, first off. If they have said they're not going to issue a plan, then probably the way to look at it is probably both. They've obviously made their decision to say they don't think a plan is necessary. It's then your job as parents to then show why that's not the case and why it is necessary. So then that goes into looking at what evidence there is with the local authority's decision, what did they rely on, and then ultimately, what do you need to get as evidence to challenge that, to show that the plan is necessary? It really does depend on what the local authority submitted with their decision, which usually isn't that much when it's a refusal to issue a plan. Normally it's something about, you know, needs can be met through mainstream resources, no, a plan is not needed. Yeah, but it requires a bit of work on both sides.
Thank you.
You're welcome.
Great.
Right, I'm not going to be too quick this time. Are there any more questions?
It doesn't appear to be, Sally.
Super. Okay, right. Well, we will say then a final thank you, and thank you to everyone for joining. And as I say, this will be recorded and popped up. And please feel free to, if you have any questions, then please feel free to email Lydia, and she will be pleased to help you if she can. And yes, thank you for joining, and this will be recorded on there, and we will be having some more future webinars. They're not every week, and we haven't had one for a few because we've been doing lots of other things with new websites and everything, but there will be some more regular webinars coming up very soon. So thank you again, Lydia, that was great, and thank you everyone for joining, and goodbye for now.
Hi guys.